Hello, everyone. I'm Paula Clarkson Chamberlain, and we're going to start our webinar titled Irrevocable Trust Demystified today. Thank you for joining us. Today, we're going to cover what irrevocable trusts are and what they aren't. There seems to be a lot of confusion about that. What are the pros and cons of using irrevocable trust as part of your estate plan? The trade-offs of having an irrevocable trust because you're giving up some control. What are some of the roles and responsibilities of the trustees, including these special notices called crummy notices and the gifting rules when we put assets into a lifetime irrevocable trust? Some pitfalls and mistakes that we want to avoid, and there'll be time for some questions at the end if you have any. So let's start with what exactly are irrevocable trusts. So an irrevocable trust is a trust that can be created either during your lifetime or when you pass away. And it benefits, one or more people or charitable organizations. But the problem with an irrevocable trust is the person who is creating it is not the beneficiary. So you can't create them for yourself. And once they're created and funded, they generally cannot be amended or modified or changed by the grantor. Throughout the presentation, we'll talk about some instances where you are able to do that. But like I said, you can create them either during your life for someone else or when you pass away, leaving your assets to someone else in an irrevocable trust. And usually they're set up because you either gave away assets, you could sell assets to the irrevocable trust, and then you no longer own those assets, and they're not part of your estate for estate tax purposes. And the trustee, it can be an individual, it can be a professional trustee, but as you'll see as we go through, the person who created the trust cannot be the trustee. Control is one of the biggest factors of setting these up. So I can't be trustee, I can't maintain control over it, as opposed to when I have an revocable trust that I create and I can be in charge of it. Now, there's a general structure for irrevocable trust, but there's a lot of different nuances on different ways to set up irrevocable trust. Some of which are intentionally defective irrevocable trust, life insurance trust, special needs trust, charitable remainder trust, and then we call it SPLAS and GRAFT. And we're going to go through those slightly as we go through the presentation as well. Each of them could have a 2 or 3 hour presentation on the different types alone. So we're just going to touch on them. So quickly, between a revocable trust, which is what most people are going to create, they're going to create that during their life to avoid probate at their passing, to allow someone else to manage their assets for them in case of incapacity so that the court does not have to be involved. So those are, when you set up a revocable living trust for yourself, you can change it, you can amend it, you can revoke it, you can do whatever you want during your lifetime as long as you have capacity. And because you're allowed to do that, you can serve as the trustee because you're in control. The assets are owned by you. So they're included in your estate when you die. So the IRS, the rules say that whenever any of us passes away, we have to value all of our assets. And if the assets exceed currently 15 million is our federal number, then we're supposed to file an estate tax return. And anything above that, it could be subject to estate tax at 40% above that. California does not have an estate tax. However, if you do have assets in other states, some rental properties or things like that, those assets may be subject to the state estate tax where they are located. And because you maintain full control of those assets, they're included in your estate, you don't have any asset protection. Your personal creditors can get to those assets anytime if you were to be sued and found negligent. Generally, when you become either permanently incapacitated, such as dementia, Alzheimer's, or if upon your passing, your revocable trust will then turn to an irrevocable trust because that means no one else can change it. On the contrary, we have an irrevocable trust. So I can set up a revocable trust for myself. I can also, during my lifetime, set up an irrevocable trust for somebody else. So I'm creating a trust for their benefit. But once I set that up, I cannot have control over it. I cannot act as the trustee. I cannot control those assets. I am not the owner of those assets anymore. And that does provide a certain benefit, because if I don't own those assets anymore, I've given them away. My personal creditors cannot get to them. They are not included in my taxable estate for estate tax purposes. So then when I die, they're not included in that up to $15 million number. So here's a simple illustration of it. So generally what you're going to have is, either transferring it from your own revocable trust or individually to an irrevocable trust. Someone else will manage it for your however many beneficiaries you have. And the trust will determine, you'll lay out the terms of how much income can they get, how much principal can they get, at what term and time frame do they get it. So when you're setting up the trust is when you have all the control to put all those factors in place of who you want to have it, when you want them to have it, and so forth. But you are relying on that third party trustee to manage it according to your terms. So with everything, there are pros and cons and trade-offs. So there are lots of advantages of it. It is by creating an irrevocable trust and either gifting or selling my assets to it, I do not own those assets anymore. So it reduces exposure for estate tax purposes when I die. It also means that if I gave away an asset right now and I live another 20 or 30 years, the appreciation on that asset is not included in my taxable estate. The appreciation is in the irrevocable trust that I don't own. So it's a great way to get that asset out. There's also the creditor protection. So assets in the irrevocable trust are generally beyond the reach of the beneficiary of the trust creditors. So for example, if I set up a trust, an irrevocable trust for my daughter during lifetime, or even when I die and leave those assets to her, her personal creditors, like if she's in a car accident or somebody sues her for whatever reason, she gets divorced. These assets, because they are in an irrevocable trust for her benefit, her personal creditors do not get to it. Now, there is in California, we do have a public policy that if there's child support involved, that a portion of the assets can be obtained for child support, because that's something we usually want to take care of, but not for like a car accident or something like that. If the irrevocable trust holds life insurance, then those assets, the life insurance proceeds, are outside of your estate for estate tax purposes. Because if I have a $2 million life insurance policy on my life that I own, that is included when I count up all of my assets when I die. I'm going to count up my house and my car and my bank account, IRAs, and my life insurance. And if that exceeds $15 million, there's going to be estate tax on it. But if I never owned that policy, and we're going to go into more detail, then when that policy pays out, it's not included when we're counting my $15 million. So that ends up being a really good thing. It also, if I had a beneficiary that maybe needed some government benefits because they had a severe disability, by putting the assets that you leave to them in an irrevocable trust, there's ways that it can protect them so that they're still eligible for their government benefits, but they still have these assets to use. We call that a special needs trust, and it allows them to continue to qualify for those needs-based government benefits. But generally, we're not going to want somebody that maybe can't manage those assets in the first place to have control of them. So putting it in an irrevocable trust for their benefit, someone else is managing it, and then allowing them to still qualify for the government benefits ends up being a huge plus for many families. We'll talk about later, there are charitable strategies and income tax benefits of using certain irrevocable trusts. And there's also ways that the grantor can direct the terms of how the assets are used beyond the life, as opposed to if I were to pass away, leave assets to my daughter in her name alone, she can use them however she wants. When she dies, she passes them on to whomever she wants. However, if I left them in an irrevocable trust for her, I can say during her lifetime, she's allowed to use them. But when she dies, I then direct. And in the document, I would say maybe those assets go to my grandchildren. Maybe they go to charities or other family members or friends. So it allows the creator of the trust, the grantor, to provide, how these assets are used over potentially multiple generations. So as I mentioned, though, that is done at the beginning. So some of the disadvantages are the direct control of those assets. Once I transfer the assets into that trust, so I transfer stock or real estate, I don't have a control on how those assets are managed. Maybe the trustee sells the piece of real estate, sells the stock, things like that, how they make distributions to the beneficiary. Outside the terms of the trust, when I created it, I don't have any control over that. So that does provide a little bit of inflexibility if there are life changes. If I create my trust for my daughter right now, and in 10 years, she develops an addiction issue, my trust may not provide for that. So that could be a potential problem. So, having to think of all the situations at the beginning based on your family, issues that may come up, is something that you're going to want to provide. Now, I mentioned earlier that technically these irrevocable trusts are irrevocable. You can't make any changes to them. There are some provisions under the California Probate Code that allow for the modification of an irrevocable trust in certain circumstances. The first being, if the person who created the trust and the beneficiary are both alive and they agree, you can modify the trust without going to court. So if I set it up one way, 10 years go by, family situation, things changed, both the creator and the beneficiary agree, we can modify the trust, just amend it, no problem. If I am unable to modify it, such as I am incapacitated or I'm deceased, then in order to modify it, the trustee or beneficiary would have to petition the court. And generally, all the beneficiaries would have to approve the changes to it, and so that we can continue on. So we've been successful with that in many situations, but you just really have to make sure that the beneficiaries are comfortable with it. Because you have an irrevocable trust, there is an ongoing administration for it too. It's a separate legal entity. So it's going to have a tax return every year. There's going to be, a trustee fee that every year that can be done. So that's just an extra cost associated with it, obviously. And then one of the tax disadvantages is that if I were to give assets to this trust, say I transfer $100,000 worth of stock to the trust for my daughter's benefit, my basis in the stock, what I paid for it, is obviously not the current fair market value. So the fair market value is the $100,000 that I gave. But if I only paid $10,000 for this stock, my basis carries over to that irrevocable trust if I give it during my lifetime. So that means then if this irrevocable trust in the future sells that stock, it's going to be the sales price minus the basis, what I paid for it, is going to be subject to capital gains tax. Now, if the irrevocable trust is created when I've died, if I own that asset when I die, it will get a basis adjustment. And then it will be put into that trust and adjusted to the fair market value on my date of death. So those are things that you're going to have to consider. Is this an asset that you want to give during life because you won't get the adjustment, or do you pass it at death? And it's weighing all the different factors. Obviously, if I give it during life, there are gift tax consequences to that. If I put $100,000 in an irrevocable trust for my daughter, I have to file a gift tax return. The first $19,000, I'm allowed to have gift tax free. So then technically, the gift tax is $81,000. The recipient of the gift, my daughter, this irrevocable trust, never pays gift tax. The recipient of gifts never does. But that extra $81,000, I'm supposed to file a gift tax return. And what happens is I can pass $15 million at death or during my life. So I file the gift tax return, and it reduces how much I can pass when I die. So 15,000 or 15 million minus the 81,000 is now the amount I'm allowed to give during my life. So oftentimes, though, that is a good thing because the expectation of that $100,000 asset, I mean, it could, go to 200,000, 300,000, 400,000 by the time I die, and I've moved all of that appreciation out of my estate for a lower amount of 81,000. So, and with creating trust, there's always, the setup fee and everything like that, trustees, the tax returns and things. Another disadvantage that can be dealt with, though, is that irrevocable trusts have their own tax bracket, just like individuals do, just like corporations do. And the bad thing, though, irrevocable trusts reach their highest income tax bracket when they have 16,000 of annual income. So that's going to push them up into the 37% for federal and, California's highest income tax bracket at a very, very low level of income. But oftentimes paying the income tax is just something you're going to deal with because you're going to get that asset protection. It's just the cost to pay. So this is where we're going to go into more of the pros, the cons, and the trade-offs. So as I mentioned, removing it, the trade-off, it's the control. It's basically, I'm giving up control, but my beneficiary is getting so many more benefits because of the asset protection, getting it out of the estate. I got all the appreciation out of my estate. And that's probably the biggest factor when these types of trusts are created, is that the IRS is going to scrutinize the powers. So there are some powers that we can build in from the beginning. They're called, one is called the power of substitution. So that means, for example, I put this $100,000 worth of stock into the trust. And let's say in 2 years, it's gone up to 200,000. And as we've discussed, there's going to be significant capital gains tax on that. Well, if I have $200,000 of either other assets, cash, or something like that, if we've included this power, I can go, hey, trustee, I want to swap that now $200,000 worth of stock for $200,000 of cash. Let's trade. And then now I get that stock back in my estate, and the trust still has a $200,000 asset. Now, if I pass away, this stock is going to get a basis adjustment because it's in my estate. So it's a way to swap out those assets. And we use that a lot for clients. We can also list that the trustee, although the trust is irrevocable, we can set up powers that they can change the beneficiaries as long as the new class of beneficiaries is like children, grandchildren. It has to be a very defined class. You always can add to the power to change to charitable beneficiary. This is always a great way that, if you left it for a child and the child, like I said, maybe ends up having addiction issues and you prefer not to leave it to them, maybe you change it and you can name a beneficiary. It's always the way to say, you need to keep in line with the rules, or else I can actually change it and you will no longer be the beneficiary. So when we create the trust, we always want to make sure, if I'm putting assets in there, are these assets I'm going to need to live on? Am I, if I have any issues or, health concerns, am I subject to estate tax? Right now, since we can all pass 15 million, if you had a $5 million estate, I probably wouldn't do it. But, it all depends on your situation in those assets. But if you expect to ever need them, then it's generally not a good idea to set it up during life. But it could be a great way to set it up when you die. So generally, if you're creating them during life, it's best that your situation be stable and you'll be able to work around not having those assets. So an intentionally defective grantor trust is one of the main ways we do an irrevocable trust. And you'll probably see in estate planning, we have lots of little names and acronyms for different trusts. So it's really just digging into what they do and not worried about the fancy names, because sometimes I'll hear like 3 different names for one similar type of trust. So don't be dissuaded by that. They're generally all the same kind of format. So, but an intentionally defective grantor trust, its benefits are, I create this irrevocable trust for my daughter, give away that $100,000 of stock during my life. So of course there's, or I can sell it, that's an option too. But let's say I give it to her. So I have the gift tax return that I need to file, and all that. So there's a benefit, like we said, that $100,000, that's the value out of my estate. So my 15 million is reduced by the taxable portion, 81,000. That asset so that's freezing the value. The asset's going to grow. So on her side, hopefully. So it's not in my estate for estate tax purposes. Hopefully by the time I pass away, that asset's grown to 200,000 or 300,000. I was able to get it out of my estate for a value of 100,000. So there's the income tax portion. So the income tax portion is generally, like I said, trusts will pay income taxes on any income that is earned in that trust in the calendar year. So if that stock earns dividend, or if there's other assets, they earn interest, rental income, whatever it is, if whatever's earned in there, if it's a regular trust, it's going to be subject to income tax. If we create the trust as a intentionally defective grantor trust, that means that I, the creator of the trust, during my lifetime, will pay the income tax on it. So let's say if that trust earned $100,000 of income and the tax rate is at 37% because it's at the highest tax bracket. The trust would then be reduced by the 37,000 if it had to pay its own taxes. But if it is set up as a grantor trust and during my lifetime I pay the taxes on it, I'm going to get a K-1 from the trust. That 37,000 will be reported on my income tax return. I will pay the tax on it. So that means that 100,000 of income has not been reduced. I paid the tax, and it's basically a tax-free gift. So could you imagine if you did that over 10 or 20 years? I've essentially given, roughly another $37,000 gift to the trust without any tax consequences. It's allowed to happen, but it can only happen while I'm alive. So once I pass away, I don't pay the taxes anymore. The trust pays its own taxes. So it's a great way to make additional tax-free gifts. And we can even set up the trust that might say, because sometimes people get a little worried about, am I going to be able to continue paying those taxes in the future if it starts earning a lot more income? So we can turn it off. So, I might want to pay the taxes for 5 years, but after that, for personal reasons or whatever it is, I can turn it off and say, okay, I'm giving up that right. Not longer a grantor trust. The trust will pay its income tax. So there is some flexibility with that. Another benefit that we use when we are dealing with gifting and transfers to trust sales is discounting. So I have an example of, let's say Jan owns 100% of XYZ Corp. Okay, it's worth $1 million today. If she were to gift 49% of the stock into an intentionally defective grantor trust for her son Max, so she's going to have to value the 49% stock. So normally you would think, okay, 49% of $1 million business is 490,000, but because that is a minority interest in the property or in the asset, there's generally a lack of marketability because who's going to want to buy a partial interest in a business that they don't control? Oftentimes we can get that appraisal discounted. And, we see discount valuations range from 10% to 40%, 15, we just guess. The appraiser will determine the appropriate discount based on the industry, how the company's set up, lots of different things like that. So it will just depend. So let's say on this one, we get a 15% discount. So instead of gifting 490,000, my gift is really only going to be valued at 343,000. So right there, I've already squeezed some of the value out, and I'm effectively, Jan is effectively giving an extra 150,000 to Max, paying any taxes on it, just because she gave a minority interest and she was able to take a discount valuation. So then in this case, Jan would file a gift tax return, report the full gift of the 343,000, even though it's a 49% gift. The first 19,000 would be subject, generally is going to be the tax-free. And then the additional 324,000 is going to reduce her 15 million that she can pass when she dies. So that's a great way. We've now frozen the value. We used the value to get it down to 343. And then hopefully during Jan's lifetime, the company's worth is going to increase. And now all the appreciation on that 49% is outside of her taxable estate. So then now we're in this position that the stock is in the trust. If income is distributed to the trust, Jan would pay the income tax. She would now, every year, she would file whatever income taxes earned for that trust with her personal tax return. And the assets in the trust are not going to be reduced. They're going to be able to continue to grow and compound, which will make it grow even faster. And her estate is paying the taxes, which is going to reduce it for estate tax purposes. So it's allowing the increase on the outside of her estate and a decrease on the inside of her estate. So, but as we mentioned, whatever Dan's basis is in that stock is going to be Max's basis in the trust basis. So when that stock is ever sold, there's going to be potentially capital gains tax. So this is one way we can do it. So we always ask when we do an irrevocable trust, is it going to be a grantor trust? Is it not going to be a grantor trust? Just depending on who's going to be paying the income taxes. There are different types of irrevocable trust, as we mentioned. The trust that we talked about, we called it defector grantor trust. The same thing applies. We call it a dynasty trust. This just means that when I die, I leave the asset to my child. The only differences are, one, it's now I've given it to them when I've died, or number two, it's not a grantor trust because I'm gone, so I can't pay the income tax associated with it. So those are very much taken advantage in people's revocable trust. Instead of leaving assets to their children directly, or sometimes people leave it over time, some at 25, 35, 45, you can leave the assets in trust for your child and allow them to be the trustee because they didn't create it, so they can be the trustee, or you can have somebody else be in charge of it, especially, if you were to pass away and you had children that were minors. You're planning it today and you have a 10-year-old. You can't let a 10-year-old be in charge of it. You probably wouldn't want them to be in charge of it anyways if it had any significant value. But you could say, if I die, these assets are held in trust for my child, and my child can be their own trustee upon turning age 40. And then those assets are in the trust. Your child does not legally own them because you have created the trust for them. They can use those assets, manage them, and make distributions to the beneficiary. And now those assets have asset protection for my child that they could not have done for themselves. My child is not allowed to put their own personal assets in there, but the assets that I have left as the inheritance can be. Okay? In a life insurance trust, irrevocable life insurance trust, we use these a lot. There is a misnomer about life insurance assets, because people will say, okay, I'm going to get the proceeds from the life insurance policy. I have a $2 million policy. That comes to me tax-free. Well, it comes to you income tax-free to your estate. But if you own that life insurance policy of $2 million plus all your other assets, your house, if you have a business, your checking account, investments, 401k, if you add all of that together and it exceeds $15 million, it's going to be subject to estate tax. So, oftentimes we'll have people that have an estate that's very close, like if you had a $14 million estate plus $2 million life insurance, you're over the limit by $1 million. That extra $1 million is going to be subject to 40% estate tax. So right off the top, $400,000 would be due for estate taxes, when you could create a life insurance trust and not be the owner of the policy. So the way that happens is I can create a trust for my child, okay? And if I already own the policy, I can gift the policy to the trust, or I can sell it. So if it's a term policies don't have any value. So I can gift it, it has zero value. And then the policy is now owned by the trust. Or if it's like a whole life policy and it does have some type of cash value, that would be the value of the gift. So what you do is you get the policy over into the trust, and now you think, okay, well, this trust doesn't really have any money, and it has a policy that it has. So what happens is every year I would transfer enough money to the trust to pay the life insurance policy. So say the annual premium is $10,000. Every year, at least usually 45 to 60 days before the policy premium is due, I, as an individual, write a check to the trust. The trustee will deposit it into their account. And then they will go ahead and use that money in order to pay the policy premium. So then when I die, I don't own that $2 million policy when it's paid out, so it's not included in my estate for estate tax purposes. It's included over and it's payable to this life insurance trust. So now $2 million worth of cash comes there. And so that cash could either be used and be distributed. Sometimes we will then take that money and buy assets out of my revocable trust. Because if I'm gone, and let's say the majority of my revocable trust and my estate consists of a business that I owned, but I owe a little bit of estate tax. I don't necessarily want to have to sell the business. Maybe I don't want to have to sell some real estate or things like that. The life insurance trustee can say, hey, trustee of the revocable trust, I have $2 million worth of cash. I want to buy some of your assets in exchange for the cash. And they basically buy and sell it. Now my revocable living trust has cash in order to pay estate taxes, pay bills, different things like that, provides a lot of liquidity, and didn't reduce the size of my estate. Some people will also use the life insurance trust as a way to have money to pay that estate tax. So if I was in a position that my estate, $15, $16, $17 million, and there's estate tax due, I can have a life insurance trust, have money over there, that when I die, there's cash to pay off my estate tax, and now my family doesn't have to do any fire sales because that estate tax is due 9 months after the person died. So oftentimes it's difficult to come up with that money quickly without having to sell something quickly and perhaps at a reduced value. I mentioned special needs trust. We have lots of clients that have children with special needs. And if a grandparent wanted to help and left money to that child, whether they were a minor or adult, it could, one, you can't leave them money to a minor. Or even if they're 25 years old, if they have significant special needs, then they don't have the ability to manage those assets. And their parents would have to get a conservator of the estate for them. So a better way to do that is usually it's the parents will set up a special needs trust for their child of whatever age their child is. And that's a great place for family members to leave money. So that money goes into the special needs trust. The parents of the child usually manage it, and it allows the child to have money, somebody managing it for them. And if the child needs to apply for government benefits that are needs-based, then those assets in the special needs trust are not counted towards assets that they own. So it allows them to still have the money there, plus qualify for those government benefits that could be very, very important for medical needs and so forth. Last, another type of irrevocable trust. It's a spousal lifetime access trust. So these are good trusts where it's basically spouses are creating trusts for each other. So let's say that you have one spouse, let's say the wife is a doctor, in a very litigious, area of medical practice. So if her and her husband create a revocable trust, they don't really have any asset protection. But if we're able to say some of those assets are the wife's, the doctor's, as her separate property, they transmute the assets from perhaps community property to the doctor's spouse's separate property. That doctor spouse can create an irrevocable trust with a non-doctor spouse. So for, some people will do that with their house or with investment assets. So let's say we transfer the house over to this doctor's spouse's assets, separate property. They then create an irrevocable trust and put the house into an irrevocable trust for the benefit of the husband's spouse. So obviously everything is going, all the same things apply about the basis step up and different things like that, the gifting and all that. But the benefit of doing this is now we have an asset that is protected from the doctor's creditors. The downside is when the husband's spouse dies, that the surviving spouse can no longer use that. Because I'm imagining that while they're both alive and married, they're, the beneficiary of the trust, the husband, is going to let the doctor wife live with them. But if there's death, if there's divorce, then there can be potential problems. We sometimes get around the divorce issue by saying, my current spouse, or if I am no longer married to this person, then maybe my children are the beneficiary. But there are problems, like I said, if one spouse dies, do you need to have those assets? because if the doctor spouse wants to continue living in that house after maybe the husband has died, maybe the kids are the next beneficiaries, and the husband will have, or the wife's doctor will have to rent the house from the children. And a lot of times people don't like that because they're like, I'm paying rent on a house that really kind of is mine, but legally it's not, and you're paying for that protection that you have and getting that asset out of your estate. And another type of irrevocable trust is charitable lead, charitable remainder trust. It's basically putting assets in. The charity is either the beneficiary at the beginning or at the end, the lead or the remainder. These are charitable remainder trusts are great ways if you have a business that is highly appreciated or other highly appreciated assets that you intend to sell. If you were to sell them and own them during your lifetime, they could be subject to capital, a significant amount of capital gains tax. But if you put it into this charitable remainder trust, charities don't pay income tax on a sale. So if the assets are sold in the trust, and then the trust usually will say for the person who's created it lifetime, they will get a certain payout. And there's formulas for how this is done. And then when that person dies, the remainder goes to the charity. And generally when we've seen this is if the business owner were to sell it during their lifetime as them the owner and pay the capital gains tax, they end up with a lot less in their pocket than perhaps if they had put it in the charitable remainder trust and took that annuity payment for a period of years. Obviously, it depends on, the person creating the trust if they live a certain amount of time. So we always have to look at that as like, what is the break-even point for keeping it in your trust or not? And then also secondary, do you have the preference to leave any assets to charity? If your goal is not to leave those to charity, but to leave them to your heirs, then this is not a good option. And you can reverse it too, that, you sell the business, the charity gets money at the beginning for a period of time, and then after a period, say 10 or 20 years, then after a period of time, it goes to your remainder beneficiary. This is a great way to do it if you don't want your beneficiaries to have anything. Like if you have children and you don't want them to have anything until they're in their 50s or 60s, perhaps. It's a way to delay it and say, I want them to work hard during their lifetime, but here's some in the future for retirement, and also allows you to get a charitable deduction on that gift. So income tax benefits, some asset protection, sometimes a little bit more money out of it too. So choosing your trustee to take care of this is a very important role because you are giving up control of that asset. You cannot be the trustee. So the trustee is a fiduciary duty. They have to act solely in the best interest of the beneficiaries, not in your best interest, not in anybody else. Generally, there's a prudent investor standard that they have to manage and invest the assets by. But if you're putting assets in, like we did with Jan and Max, she's putting in a 49% interest in a business. That's not really investing as a prudent investor. So we can put terms in the trust to say we're waiving that, or we're allowing the assets to be concentrated in this one business. So if that's going to be happening, then we always need to look at that so that you're protecting the trustee that you're needing. The trustee has to keep all the beneficiaries informed, know what's going on in the administration, give them an accounting every year of the income distributions and things. That irrevocable trust, since they're irrevocable, they have their own tax ID number. Or if I have all my assets in my revocable living trust, I die, my trust becomes irrevocable, and I create that dynasty trust for my daughter. Now that trust cannot use my social security number, we'll get a separate tax ID number for it. And these are all separate taxable entities. So irrevocable trust file tax returns on IRS Form 1041 and California Form 541. And annually, just like we do with our personal tax return. And then the trustee is to remain impartial, balance all the interests of the beneficiaries, the remainder beneficiaries, and really follow the terms of your trust. One of the important roles of the trustee is giving certain notices. We mentioned earlier when you gift to the trust, that first net right now it's 19,000 a year that we can give gift tax free. So we have a notice. It's called a crummy notice, and it's based on a case, crummy versus commissioner. So going back to the example of I give $100,000 into an irrevocable trust for my daughter. Generally, the first 19,000 can be gift tax free, but I have to put some strings on that. So in order for that first 19,000 to be gift tax free and apply for my annual gift tax exclusion, the beneficiary has to have the right to get to that money. So it's called a present interest. So if I put that 19,000 in the trust and say, you can't touch it, then I don't get the benefit of it being tax free. So that's something you can weigh. Most times people will want to do this. So then what happens is we build into the trust that says, trustee, when we give you that money, then you have to provide a notice to the beneficiary, usually like 30 or 60 days. And it'll say, transfer has been made to the trust, a gift, and you have 30 or 60 days to pull this out. Of course, we never want them to do it, okay? Because that would defeat the whole purpose of the trust. So generally, you're going to explain that to the beneficiary on why it's not in their best interest to pull that money out. So then when the time runs, then the trustee will turn around and put that money into an investment account or somehow other use those benefits. So that keeps that first 19,000 gift tax free. If my beneficiary or my trustee does not send out those crummy notices or the trust doesn't provide for that, then I do not get the first 19,000 of the gift tax free, and everything I put in the trust is taxable. So you're going to have to just depend. And it's really, really important that the trustee gives out those notices. So for example, like in a life insurance trust, the reason that I had said that usually about 60 days ahead of time, I transfer the money in before the premium is due so that my trustee can then, I write the check to the trust, it's the gift. The trustee puts it in the trust checking account. They send out this crummy notice to the beneficiary. They wait the period of time lapses, then they take the money and they pay the life insurance premium. But if the beneficiary came back and said, no, I want that money, then there's no money to pay the life insurance premium. And in that case, the trust could fall apart. If the money wasn't necessarily going to be used for to pay a premium, then it's probably a no hard, no foul, but it does tell you, hey, should I be continuing to put money into this trust if the beneficiary is just going to be pulling it out? And these are great ways. We'll see a lot of times clients, instead of setting up 529 plans because maybe they don't know if their grandchild is going to go to school or not, to college, or if they're even going to need that much, what they do is they will set up an irrevocable trust for their grandchildren, and they'll gift up to 19,000. And if you had like grandparent, husband and wife, or two grandparents, they can each transfer 19,000. So like my parents could transfer a total of $38,000 into a trust for my daughter every single year, tax free. And you can imagine if that started when she's, 1, 2, 3, if they do that every year for even 10 or 15 years, it's going to start multiplying and would be a great way to get her a good start on life. The difference with, a 529 plan, you can gift and put that money in there as well. The benefits of the 529 plan is you have tax-free gifts or growth, but the money can only be used for certain educational expenses. And then if it's not used, part of it can be rolled over to like an IRA. But if I put money into an irrevocable trust, then when the child becomes, an adult, maybe some of that money is used for college education. Maybe some of it's used to buy real estate, to pay for a wedding, to pay for other things. So, by putting it in the irrevocable trust, I have a little bit more flexibility on what it's used for, but I don't get the benefits like the 529 plan where it grows income tax free. But again, I can set it up as a crummy trust where I pay the income taxes. So technically it's growing income tax free on the trust side. I'm just paying the income taxes on it. And then, if you don't want to generate a lot of taxes, then you talk to the trustee and see if there's ways the trustee can create it for tax-free bonds or more for growth, not necessarily income and different things like that. So there's a lot of ways to look at that. But sending them crummy notices when you're making when you want to take advantage of the $19,000 annual exclusion is necessary. And it has to be done every single year. That's the biggest thing that people forget. And the creators of the trust, every time they put money in, they have to file their gift tax return. So it's very, very important that both of those things are done every time assets are put in the trust. And anytime assets are put in the trust that is not cash, those assets need to be valued, whether it's stock, partial interest in a business, real estate, whatever it is, you're going to need to get that appraised, because that appraisal of the valuation is attached to the gift tax return that's filed. So those are the biggest things that we need to look at. So those in addition are looking at some more of the pitfalls, and the stakes are going to be the retaining the too much control, like we talked about. I cannot be in control of a trust that I've created. Potentially transferring wrong assets, because maybe they're going to trigger capital gains. Maybe I need those assets back, different things like that. Forgetting or not doing the crummy notices. The trustee has to be responsible for that and keep copies of it. We like them to give it to the person, have the person sign off, the trustee keeps a copy of it. Selecting the wrong trustee, or do they not know how to manage it? Depending on what you're transferring it in, they may not have the ability to manage those types of assets, whether it's a business interest, real estate, different things like that. So make sure that you choose someone that's going to follow it. And it's really, really important that you coordinate this. If you create an irrevocable trust, coordinate it with the rest of your estate plan, especially if you're doing it during life. That's really, really important. So always looking to see, is it right for you? Is it not? Right? The great thing, last year, the estate tax exemption increased to $15 million. So a lot of people are not going to be subject to estate tax anymore. So this eliminates a lot of the need to give during life. So that's a really good thing. Do we want to hold the life insurance outside the trust, and avoid inclusion to throw you over that estate tax level? Do you have a disabled child or other family member that may have addiction or things like that we need to set those up for during life? Are you concerned about future creditors, whether, making gifts during life or when you die, putting it in those irrevocable trusts for your children or other beneficiaries? Or even, we see a lot of people that help out their parents. So they might say, hey, I want to set aside $500,000 for my mom because I want her to be taken care of. But if I gave that money to they died and the money went to the parent, and the parent dies, the parent chooses where that money goes. But if they set it up in an irrevocable trust at their death and say, I'm setting aside $500,000, trustee, use this money to pay my mom's rent or to supplement her income. But if she dies and there's still money in there, it's going to go where I want it to go and stay and, go to my beneficiaries and other people. So there's a lot of control that you can do with that. You're freezing estate taxes too. If I leave the assets in trust, a dynasty trust for my daughter, and if I avoid estate taxes, they're now, or even if I have to pay estate taxes, when they come to her, because they're in that irrevocable trust, she doesn't legally own them. That's why she has the asset protection. Because she doesn't legally own them, they're not going to be counted towards her $15 million when she dies. So that means that although estate tax may be paid at my level, it won't be paid at my child's level. It won't be paid again at my grandchild's level, no matter what the value of this irrevocable trust grows to. So it's a great way to kind of stop that estate tax bleed on how you're doing it. Again, you're not going to make it during life if you need those assets. So we always have to consider a lifetime gift or a gift at death. If you're way below the estate tax threshold, making those gifts during life is maybe not a good thing, but doing it at death might be. Just considering all of your situation that could change is always important. And making sure that if you're going to do this, that you actually have someone that is qualified that can help you. Usually when we're doing it, we're, as the estate plan attorneys, we're working with your financial advisor. We're working with your CPA to look at all these different, estate taxes, income taxes, capital gains taxes. What is your, need for retirement? Do you have enough liquidity to do the things that you want to do for the rest of your life? So, you come first. So making sure that all of those things are taken care of. So I know there's a lot of information, and as I mentioned, we could easily go for a couple hours on all the different types of irrevocable trust. The bottom line is they do have in common is that they're irrevocable. You're making, someone's making a gift to that trust, losing control of it, filing the gift tax return, and looking at all the different tax consequences. So now I'll leave it open to if anybody has any questions, please feel free to put them in the chat. And but if you don't feel comfortable with that, you're also always welcome to reach out to us individually if you have any questions or want to talk about your situation specifically. So either I was thorough or everybody's completely confused, because at this point we don't have any questions, but reach out to us later if you decide you do. So next month, I want to remind you that we have our back to school planning. The 3 estate planning documents your college kid needs and why is going to be presented by attorney Cassidy Russell on July 15th from 12 to 1 again. There's a QR code if you want to register. You will also get a copy of this presentation in your email, so you can register there, or you can register on our website. Thank you very much. I hope you have a wonderful rest of the day and enjoy the week. Thank you.